was to be decided, my lord, I am seeking pass over because my learned senior
today for that purpose.
certainly, my lord.
Is the main dispute settled?
12.2.
No, the main issue has not been settled, my lord.
12.1 settled.
12.1. I am not in 12.1. I am in 12 and 12.2.
And for the respondent in those two matters, I am ready with arguments.
My lord, we are also ready with the argument. My learned senior is on his legs. My lord, I am just seeking a short pass for him.
Mr. Ramu, don't make it a matter of your budget. I mean, decide by decide.
My lord,
The dispute is settled. He said everything is settled.
because I don't have any instruction.
If I can pass over the judgment, my lord.
Sure, the judgment.
After my lord.
All right. After me, kitne matter say?
Because in fact in 12.1 it is only the father-in-law and the husband is not involved otherwise.
There is only one property.
My lord, learned senior.
Yes, Mr. Navret.
Matter number 12 and 12.2.
We are dealing with, you are appearing in 12.
12.
Give us Domestic Violence Act. Yes. So, which are the penal provisions under the Domestic Violence Act?
Lord, let me just explain what my line of argument is going to be. Lord, consistent view. And Lord, I did not see any judgment. Is that this is essentially a civil remedy. So, Lord, I proceed on the basis that remedy or the kind of relief which is granted under the Act, insofar as sections 12, 18, 19, etc. are concerned, it's, my lord, a relief in the nature of civil remedy. So I'm not questioning that. Lord, my argument is going to be based on a few other aspects. First is,
Yes.
Lord,
Mr. Navret, the issue is this. If these are not criminal proceedings, they are civil proceedings. For example, take a case of a civil suit. There are well settled parameters in which cases it can be thrown out at the threshold.
yes,
Now, look into the intention of the legislature. If this is not a penal statute, can the court interject by way of 482 and match the complaint under section 12?
therefore, Lord, last time also I said, I repeat it. 482 is not only for quashing. 482 is a very wider kind of jurisdiction, and therefore your lordship may not see it from the prism of only that quashing proceeding which is not maintained under 482. So, Lord, this is my response to that, Lord, quashing aspect is concerned. Apart from that, there are some other aspects, I will go to that. Lord, my submission is, Lord, I have made in my written submissions a table showing under the CRPC, there are about 17 provisions where the relief in the nature of the civil, the relief in the nature which is granted by the civil courts is grantable. I also made a table under the CPC showing that relief which are essentially granted by the criminal courts can be granted under the provisions of the CPC. Lord, I will show that table first. So this first line of argument. Second,
Let us proceed on the footing for the time being.
Lord, may I just
Just one
may I
query.
just give the outline and then
One query we want to ask you.
yes,
Suppose we are with you that 482 power is available
yes,
because it is maintainable before a court of magistrate. Right? Two queries. One is, if assuming that you are right, for quashing offences, there is well settled legal principles laid down. Basically, it has to be abuse of process of law. What should be the parameters for interference? Because it's a beneficial legislation for women. Right? What what should be the parameters? That is number one. Number two, there is a provision under the Domestic Violence Act which says that in other civil proceedings which are pending, reliefs under section 19 onwards can be sought.
Can be granted.
Correct.
Section 26.
Correct. So therefore, we'll give an example. Suppose there is a petition pending under section 9 of the Hindu
Before the family court.
Family Code. Now, if your argument is accepted, in that petition, possibly reliefs